Welcome everyone. Welcome to Deception Stoppers here with me and Moses, Mark and Moses. Okay, today as you've been following, for the ones who've been following, as you know, we have some legal proceedings that went on and some legal proceedings that were happening in regards to the Franklin County Domestic Court. Now, these matters, as you all know, these matters have been going on for more than 2 years now. 2 years. And just as I said in the beginning, this thing is fresh every day until it's resolved. There is no, oh, well, this much time went by and everyone moves on with their lives. No, you're never going to get a chance to move on with your life, because everyone who violated will be held accountable, okay? And we have some big things coming up here. We have some other court proceedings coming up here. And we want to talk about recusing a judge. I want to talk about that for a minute. Okay, now when a person is in court in the state of Ohio, if the judge has any appearance, okay, any appearance of bias or prejudice, then he could be recused. All there needs to be is an appearance of that bias and prejudice, all right? And there's also something called the Judicial Code of Conduct, okay? There's something called the Ohio Judicial Code of Conduct. Now, in the Ohio Judicial Code of Conduct, it spells out a set of things that should not be tolerated. You know, it spells out, well, let me rephrase that. It spells out several things that the judges should abide by, all right? And bias and prejudice and harassment is a canon rule. I think it's canon rule 2.3 right off the top of my head. I could be wrong, but I think it's canon rule 2.3, bias, prejudice, and harassment. Now, bias is being biased is not looking at the legal rights of both parties equally. Being biased is being on one person's side with no reason to be on that person's side only. Okay, so let me give you an example. If I'm in court as a plaintiff and I make a complaint against someone and they put something in and they deny my complaint, the judge should treat both situations in a neutral manner until they try the facts and get down to the facts of the matter. All right? The judge should not be on my side or on the other person's side unless there is a credible amount of evidence that have been provided early on to allow that judge to form that conclusion, okay? So bias is just being on one person's side for personal reasons or other nefarious reasons. Now, harassment by a judge cannot harass you in the courtroom, okay? That's against the canon rule. That's against the canon rule. They cannot harass you in the courtroom. They cannot make remarks to you like asking you, did you bring your toothbrush today? Did you bring your toothbrush today? Because you going to jail. You bring your toothbrush today? Or they can't say things like, well, you know, I could deem you a vexatious litigator, or you know, I have agreements with courts all around the country, and I could have you deemed a vexatious litigator, and I could have you, you know, if there is nothing to support why you should be vexated. All right, okay. Now, these are just things that are harassments that are put in place to intimidate you for some reason or the other. Now, Another thing I want to talk about is equal protection of law and due process. Okay, I want to focus clearly on due process. Due process is affording someone a process that is fair, by the rules, and done in a timely manner with regard to the matters at hand. Okay, so that means no bias, no prejudice, and definitely no harassment, and timely decisions. Okay, like if you've watched some of our previous videos, we talked about the Ohio Constitution particularly spells out in the Bill of Rights a category that's called redress in court. So the redress in courts under the Ohio Constitution specifically addresses that redress in court should always be afforded to an injured party, and redress in those courts should also guarantee a prompt decision on the matters. All right, because these court officials in Ohio, they have become comfortable with thinking that they can just set hearings, and they can set hearings whenever they feel like it without being held accountable. Now, that's not the case, because there's provisions in the state constitution that particularly address that. Okay, in the Bill of Rights of the Constitution, they particularly address those type of actions. All right, because those can be viewed as a form of abuse of process and a form of violation of the 14th Amendment. And another thing I want to talk about is the 7th Amendment to the United States Constitution. The 7th Amendment of the United States Constitution guarantees an injured party a right to a trial by jury, or it guarantees a trial by jury. Okay, now in Ohio specifically, the Ohio Constitution specifically states that a right to trial by jury should be inviolate. Okay, it should be inviolate, which means if you request a trial by jury, all right, you should have a trial by jury unless the case have come to a settlement in the early stages. There should be no summary judgment, no motion for summary judgment, or no motion to dismiss should be entered, should be accepted, all right, to abridge that trial by jury. Okay, in the event someone goes in that courtroom and they invoke all of their rights secured by the United States Constitution, then they should be afforded redress in that court. All right, anything contrary is notwithstanding. Okay, anything contrary is notwithstanding. That's Article 6, Clause 2 of the United States Constitution. It specifically says anything to the contrary is notwithstanding, and it is binding on all courts. And see, in our situation, these people, they have adopted so many customs that these actions have become commonplace, because they don't think that there's any ramifications for these actions that they're doing. But they're about to find out. Okay, they're about to find out that there is many ramifications for those actions. All right, and those ramifications most likely is Monell claims. Okay, that's a Monell claim is the ramification for the action. Okay, because or a RICO violation, because these people, they have become comfortable because they know that they get these, that they assert these judicial immunities, so these judges feel like they're invincible. But here's the thing: if the judge asserts judicial immunity and is granted that immunity, most oftentimes that immunity, that judicial immunity, is granted to that judge because that's the environment in the era that we live in. You know, that's the custom that has become the norm. All right. But the municipality can still take a hit. So even though the judge may get judicial immunity, that does not kill the claim. All right. The reason why it doesn't kill the claim is because a municipality cannot assert judicial immunity because they are not a person. Okay, they're not a person. You know, they're not persons as described under the law. So they will not be entitled to any type of judicial immunity. So the municipality takes a hit. So if the municipality know that these judges that they are employing are not following the rules consistent with their oath of office, then those are customs. And if that can be demonstrated, and shown that there exists a pattern of that, okay, then that municipality has to take the federal hit. So the municipality will take the federal hit. The municipality will take the federal hit, not because their judge did that, not just because of isolated incident, but it has to exist a pattern. All right, it has to exist a pattern because I think it's called respondee superior. It's something like that, where the municipality cannot be held liable just for the single act that their judge do, just because they're an employee, just because of the employer-employee relationship. Okay, the employee and employer relationship is not enough for that Monell claim to be solid. In order for that Monell claim to be very solid, it has to exist a pattern, or it has to exist a custom that has been committed over a certain period of time, and there has to exist that pattern. All right. In the last video, we talked about one of the strongest customs, one of the strongest elements. One of the strongest elements for the Monell claim is a law that has been enacted by the state legislature. Okay, because again, a lot of these laws, some of them are passed with the assumption that a person is ignorant of their rights. So these state officials, they become comfortable with creating these violations, and it becomes the norm to them. Okay, so we are here to challenge those norms. We are here to challenge those norms, and we will be keeping you updated on how this thing progress, because it's not over. The battle really has just begun. The gloves have really come off at this point, with the fist dipped in chalk. So yeah, it's really, things are about to really heat up and get really nasty and ugly. And yeah,
that was basically training mode.
Yeah, that was
training mode.
Yeah, that was definitely training mode. That was
preparation, learning, and you know, it was great.
Yeah, that was the swimming pool lining. Now it's time to fill up the swimming pool. It's time to go swimming. Right? So again, we will be keeping you guys abreast on this. Okay. And yeah, these municipalities will be taking a hit. And again, in the Monell claim, there has to be a final decision maker, like a chief justice or a court of appeals, that upholds the violation of the Constitution. Okay, and any federal court has jurisdiction over that. Any federal court has jurisdiction of a violation. A violation of the United States Constitution gives any federal court jurisdiction. Okay, it's called federal question. It's called a federal question, right? Federal question is a violation of the United States Constitution. Okay, whether it be the First Amendment, the Fifth Amendment, the Seventh Amendment, the 14th Amendment, it doesn't matter. Okay, if there's a violation that caused a party to be injured and deprived the party of their right, then that is available for redress in any federal district court. They have jurisdiction over that matter. All right, and another thing that I want to get into talking about too is loyalty. We want to talk about loyalty. Okay, loyalty in terms of like oaths and contracts. Loyalty is very important, whether it be loyalty just to an individual or just loyalty to what you believe in, or loyalty to your spouse, or loyalty to your children, or what have you. Loyalty is very important because there's nothing that's higher than loyalty. There's nothing on this planet that's higher than loyalty. Loyalty is an element of love. Loyalty and trust are chips off of love's shoulders. Right? And those are very important things. So loyalty is something that is to be taken serious at all times, okay? And some people take their loyalty in their religion more serious than they take loyalty in their job. But loyalty of any kind is very, very important. It's very, very important. And integrity is too. Integrity is very important as well, you know. Integrity is very important. But we just wanted to update you guys and let you know pretty much what's going on. And things are really about to heat up here. We have some public news stations who have agreed to pick this matter up as it progresses. We have contacts, so this thing is about to get big at this point. Because we've been a little bit, we put things on YouTube, but we haven't really done any kind of press releases or media releases on this particular issue. But all of those things are now in place, and we're all full steam and ready to go. So it's going to be very interesting how this stuff progresses.
Steps.
Yeah, so we'll update you guys. And again, the officials with the Ohio Supreme Court, the Chief Justice, namely Maureen O'Connor, she has been used to denying people redress for court cases and abusing process. I think the gentleman.
I mean, how can you get? It's really interesting. It's really mind-boggling to me. It's like you're on TV or and you're talking highly of the Constitution, but all the stuff you did, such as obstruction of justice.
Yeah.
And violating the Constitution, but you get on TV and say that, well, this is written in stone and it's important. Like, what? When you're caught, if I was like that in that position, and I was exposed like that, I would lose a lot of face, man. If I'm out there, especially messing with someone with a huge audience, you're out there, and people are going to be able to see that and see what you did. And what is that going to say about you? What is that going to say about your legacy? What is that going to say about you? Like, that's just crazy, man. How can you not care about that? You don't care about your legacy? You willing to put your legacy on the line? Like, just like lying and commit crimes on people? Hey, I guess that's just how it is these days. That's the new thing.
Yeah, but we're gonna make it an old thing. It's been going on for quite some time. I believe there is an attorney by the name, I think his name is Eric Dieters. He's going through something right now where he's been waiting 6 years. He's been waiting 6 years for his case. 6 years for his case to be heard.
What kind of case did he have?
I think I'm not sure. I briefly got briefed on it. I think it was something to do with some type of medical malpractice or something like that. So yeah, he was venting in how she protects these medical people, medical professionals from lawsuits and things of that nature. Ohio really needs a good old-fashioned douching, and we gonna be diligent in getting that to them. But we're not gonna drag this thing out any longer. We just wanted to update you guys, let you know what's going on, and let you know that the battle has just begun. Technically, it has just begun, and we will be keeping you abreast on everything. And do you have anything else to say?
Nada.
Enjoy the channel, leave your comments, tell us what you think, and we'll see you again.
Cuidados.
Au revoir.